Welcome and welcome to the free legal advice show on British Muslim TV. I'm your host, Ilyas Bulbulia, and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I should be able to cover a vast, diverse range of matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your questions are relating to English law, please feel free to pick up the phone and to give me a ring on the landline number which appears at the bottom of the screen. Alternatively, you can send me a message on the WhatsApp number that also appears at the bottom of the screen. Now, every week we get numerous calls and messages on immigration law, which is fantastic. But I can advise on a more diverse range of matters as well. So even if it's a family law matters, criminal law matter, whatever your questions are, please do pick up the phone and get in touch. A couple of minor points before we get going. On a live show, it's not always possible to take very detailed information from callers who call in. Sometimes it transpires that the matter is quite complex, or sometimes I need to look at documents before I can advise properly. If that's the case, if your matter is complex, or I need to look at your documents, then I will arrange for you to send your documents in or for me to have a more thorough discussion with you off air. And it's part of the free legal advice show. So any advice that we provide after the show's finished, after I've had a more detailed discussion with you, or after I've looked at your documents, again, part of the free legal advice show, and the advice is absolutely free of charge. So feel free to get in touch. As I've said, two ways of getting in touch. Landline number, you can speak to me live on air, or the other very popular method of contacting me is to send me a WhatsApp message. And as we've started the show, I've had a number of messages coming in already, which is fantastic. So please do feel free to continue to send your messages in on WhatsApp. But it's always good to hear from our viewers as well. So please do feel free to pick up the phone and to give me a ring, and we can have a discussion live in the studio. Okay, got a couple of questions coming in. Let's look at the questions. First question relates to an immigration law matters. I think we touched upon this at the end of the show last week, but I think we were quite rushed and I couldn't therefore provide a very detailed answer. So let's start with that. First question of the day on WhatsApp is as follows. Dear sir, my wife arrived here in the United Kingdom on a spouse visa. She needs to go back to Pakistan to complete her university course. Please advise as to how long she can stay in Pakistan to avoid her visa being made void. Her visa is up for renewal in 2023. So these things do happen. An application for a spouse visa is made where somebody wants the husband or wife to come to the United Kingdom, live here in the United Kingdom, all well and good, applications made. But then the parties realise, you know what, there are things that still need to be completed back home. It may be that somebody has a job that they can't leave straight away. Or, as is very common, like the scenario here, there's a husband or wife who's coming to the United Kingdom on a spouse visa, but they are partway through their university studies. They might have a year left, 2 years left, and they don't want to give up their studies, which they're doing back home in India, Pakistan, wherever it is. So question is, can you go back, or do you have to live in the United Kingdom? Well, look, on a spouse visa, there's no hard and fast rules relating to absences. So there isn't anything in the same way that you have for nationality applications, where it's quite prescriptive. So there's nothing which says, oh, you must be in the UK for at least 9 months in the year, or any absence can't be more than X number of days. There's nothing like that. Certainly when you apply for an extension in 2023, there won't be a problem. As long as by that stage, wife is here living with you, she will definitely get the extension. The only issue with spending a prolonged period outside the UK when you're on a spouse visa is a problem which could occur at the indefinite leave stage. So 5 years down the line, when wife is applying for permanent stay on the basis that she's held a spouse visa for 5 years, at that stage, the caseworker will look at absences. Now, as I've said, there's no strict rules as to absences, but in reality, spouse visas are there for the parties to live together in the United Kingdom. They're not granted for parties to live abroad. The whole purpose behind a UK spouse visa is that the husband and wife will live in the United Kingdom. But having said that, there isn't a strict rule on the level of absences which are permitted. So the caseworker will take a sort of a global overview of absences. Now, if it's the case that the absences are 3, 4, 5 months in total in a year, and then after that, the next 4 or 5 years, you've lived together as normal, you haven't taken any extended periods of absences, caseworker might say, you know what, it's been 4 or 5 months of absences in the first year, we'll ignore that. So a lot depends on the view that the caseworker takes. My view always is that, let's say you've taken out 4 or 5 months in a year, you should be able to get away with that. I think the problem occurs when you go beyond 6 months and your continued absence is, let's say in a year, around 7, 8 months. I think that's where the difficulty arises, because the caseworker could easily take the view that as far as that period is concerned, that shouldn't count as your 5 years which you used to get indefinite leave. You know, that was really a period of time that you were outside the UK. So in answer to your question, there aren't any hard or fast rules. You know, the caseworker, not at the extension stage, but at the indefinite stage, will take an overview of the level of absences and then decide what is acceptable. Personal view is 4 or 5 months in the first year, second year might be okay. It's when you're getting towards 7, 8 months in a year in terms of absences that it may result in that year being disregarded when you're looking at 5 years continuous residence. So if that year is disregarded, instead of 5 years, you've ended up with 4 years. So you're going to have to do an extra year. So that's where the issue might arise. Hope that answers your question. As always, to speak to me live on air, or if you're not sure about the answer that I've given, please feel free to ring on the landline number which appears at the bottom of the screen. Okay. Another question that's come in, quite a long question. Let me read the question out, and I've not looked at it yet. Let's look at the question together. The question is as follows. Salams, I've got a question. I bought a house in Pakistan, which I gave to an older sister to live rent-free for 7 years. Then I spent a lot of money, it says 10 lakh, probably about £7,000, on the daughter's wedding. We went there to attend, but found that the family were always thankless. I asked her to leave the property. A lot of damage was done. There's no relationship with the family anymore. So in terms of that issue, that's really, if there is an issue as to what the legal position is, obviously this is an issue that has arisen back home. So any legal rights would have to be enforced through the courts in Pakistan. Let's look at the next question that's come up. Question relating to compensation, slightly different question. Question relating to compensation, and more particularly in relation to data breach, quite a hot topical area. Somebody who wants to claim compensation from a GP practice due to a data breach. My personal view is this: you do need to look at how severe or serious the data breach was, and obviously the data that a GP practice holds is quite sensitive data because it relates to somebody's health condition. So it is, in that sense, very sensitive information. It's not just somebody's name, date of birth, address, where they work. It's quite personal. It's difficult to see how data could be more personal than that. It's to do with somebody's health. Somebody might be ill, they might be on medication, etc. So in that sense, it's quite a serious matter. Now, in terms of pursuing a claim, potentially there could be a claim for a breach of the data protection principles, principles that in terms of disclosure, the documents can only be disclosed to the individual, or if the individual has given consent to the documents being released to somebody else, to that individual. You can't disclose outside that very tight number of people. My personal view is this, that in terms of what you should do, you should look at complaining to the GP, look at complaining to the local NHS board. If there is something that you can do outside the court system, you should do that. If that results in compensation, it's fine. If it doesn't, you could look at bringing a claim. Now, I know you're specifically saying, are there lawyers who would take this kind of matter on effectively on a no-win, no-fee basis? I'm sure there are lawyers who will do that. The difficulty I see is this, that this is quite a specialized area of law. So it's not like employment law, immigration law, property matters, which you'll find loads of lawyers doing that. This is quite a niche area. I think the difficulty is finding somebody who has expertise in that niche area. It may be that you're going to have to speak to a litigator who has experience of data protection actions. Will they take it on a no-win, no-fee basis? I suspect it may depend on the level of compensation that they think that they may be able to recover for you. So it may be possible. It does actually require advice and assistance from a specialist litigator, somebody who litigates in this particular area of law, because it's quite different to normal litigation. It's not the same as breach of contract or property disputes or car accidents, etc. It's quite a niche area, so you're going to have to find a litigator who's got experience in this area. Potentially, from what you've said, it does look like there is a potential claim there. So best of luck in trying to find a litigator who takes this kind of case on. Now, if you're not sure or you've got follow-up questions from the answer that I've provided, then feel free to give me a ring and I'll try and assist you. We're going to be taking a short break. We're going to be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, you can ring on the landline number which appears at the bottom of the screen, 01924 231 083. Your call will be put through to me live in the studio and I'll be able to discuss your query with you. But as always, another popular way of getting in touch is to simply send me a message on the mobile number which appears at the bottom of the screen. I'll receive your message here and I will be able to address your questions live on air. And if you're not sure about the answer that I've provided, you can give me a ring or send me a follow-up question. Now, we've had a number of questions coming in, which is fantastic. But if you do want to speak to me live on air, you can ring on that landline number. Okay, let's look at the next question that's come in. My partner is going to apply to renew her 2.5-year spouse visa. She has passed the A1 test in English. What letters and supporting documents are needed to support the application? So it's somebody who's here on a spouse visa, and somebody who comes to the United Kingdom would normally be granted a 2.5-year visa. And then another 2.5-year visa, then it results in indefinite leave after 5 years. So the first grant is for 2.5 years. And what we're being asked here is, at the 2.5-year mark, what really needs to be done to extend the visa for another 2.5 years, to take the spouse to the 5-year mark. So it's at the extension stage. What do we need to do? Now, what I've just noticed there when I was reading the question out was that what our viewer says is that spouses pass the A1 test in English. Now, I'm not sure that that's correct, actually. Now, if it is an extension application, so spouse has already been here for 2.5 years and spouse is applying for an extension, the English test isn't the A1 test. It is the A2 test. So it doesn't look like the correct test has been done. So it's not the A1 test, it's the A2 test for the extension. Now, if your spouse's English ability is quite good, quite high, then instead of doing the A2 test, your spouse could potentially do the B1 test, which is higher. But what's not acceptable is the A1 test, because the A1 test is actually the test that is done at the initial stage when your spouse applied for a spouse visa to come to the United Kingdom for the first time. The A1 test was done at that stage. So you used the A1 certificate to apply for a visa to come to the UK. Now we're at the extension stage. At the extension stage, it's a higher level of English that needs to be done. It stands to reason, doesn't it? A1 is done at the outset. At the extension, it's the A2 which is done. And at the indefinite leave to remain stage, it's the B1 that's done. So it's stage by stage, the English language requirement gets tougher. But at this extension stage, really the requirement is that your spouse has to do the A2 test in English. Now, English is just one of the requirements that has to be fulfilled. The other key requirement, apart from the English requirement, and this is the key really, this is where the majority of applications run into difficulties. The main criteria is that the financial requirement has to be met, and there are quite complex rules surrounding how the financial requirement is met. So if your case is anything other than straightforward, you should take advice from an immigration lawyer. Let me tell you briefly and in general terms how the financial requirement is met. Now, as I said at the outset, there are complex rules depending on the different types of income. There are different ways in meeting the financial requirement. But the simplest way of meeting the financial requirement, and the vast majority of applications are based on this. They're based on the husband and wife, or the husband alone or the wife alone, earning £18,600 per annum. So that could be jointly, or it could be one party earning that, the other party not working. So the requirement, in most cases, there are exceptions, there are other ways of meeting the financial requirement, but in most cases, what you need to demonstrate is that the husband and wife, or either of them, are earning £18,600 per annum. That's the key. So one is you need to be earning that. The other issue is, how do you demonstrate that level of income? What is the documentary evidence? What's the documentary requirements here? Because obviously one is to say, look, we're earning £18,600, but what do you need to submit? And that's the key issue here. General terms, you need to submit your employment letter, which will confirm certain things, and I'll come back to that, essentially confirming your employment and your earnings. If you're both working, you need an employment letter from both employers. Secondly, you would normally need to submit 6 months of wage slips from that one employer. Now, if it's the case that you've been employed for less than 6 months, then there are different rules which apply. You might have to submit 12 months of wage slips, so you might have to combine wage slips from your old employer and your new one. But the key thing here is, in general terms, you confirm or you provide documentary evidence confirming your income by submitting an employment letter, by submitting 6 months of wage slips, and then 6 months of bank statements showing that the money's gone into the bank account. That is really the key document when it comes to extending a spouse visa. English, we've covered. It's the A2 test. Straightforward. You simply go and do the test. The finances is where the issue is. You generally have to meet the £18,600 requirement. That's the annual earnings. And there's a requirement in terms of the kind of documents which need to be submitted. Now, that is, I'm dealing with the financial requirement in very general terms. taking a very broad brush approach to that, because it is quite a complex area. It may be that somebody hasn't worked for the employer for 6 months. It may be that they are in receipt of disability benefits, in which case there's a different financial requirement. It may be that they've got different sources of income. So it's not just employment income. They might have rental income. They might be a director in a company receiving dividends. They may have shares. They may be in receipt of a pension. There's a whole host of different types of income which somebody could be receiving. And there are rules which govern not only the type of income which is acceptable, there are rules which govern the kind of documentary evidence that needs to be submitted to substantiate that level of income. So if your matter is complex, as I said at the outset, if your matter is complex, certainly in terms of finances, you should seek the advice of a specialist immigration lawyer who can advise you properly in terms of how the financial requirement should be met. So that's general terms. English is a requirement. Finances is another requirement. I'll just run through, because you've asked specifically what kind of documents need to be submitted. Let me run through the other documents which need to be submitted, which generally speaking shouldn't cause a problem. So you'd submit a copy of your passports. Husband and wife would submit a copy of their passport. You would submit a copy of your marriage certificate, because obviously it's a spouse application. It's based on marriage. I know it's been submitted before to get the initial visa, but you should submit it again. So you would submit the marriage certificate. In addition to that, what I would normally do is, if there are children from your relationship, you should submit the birth certificate for the children as well. So when the caseworker looks at it, he or she gets a proper picture of the family dynamics, and it's also something that they look at when they're assessing whether this relationship is genuine or not. So passports, marriage certificate, birth certificate, all straightforward. We've talked about the English certificate, which is again, it's the A2 test at the extension stage. That's all well and good. We've talked about finances, which is a distinct area. And as I said at the outset, if the matter is complex, you should normally discuss the matter with an immigration lawyer who is familiar with these kind of cases. Next requirement is the accommodation requirement. So obviously you need to demonstrate that there is sufficient, adequate accommodation for both of you to live in. So it could be that, let's say, for example, if you own the property, you might submit your deeds. If you're a tenant in the property, you might submit your tenancy agreement. If you're living with family, you might submit a letter from the family member who owns the property confirming they own the property, they're happy for you to live at the property. So you'd look at the accommodation requirement as well and fulfill that. Again, it depends on your individual circumstances. So we've looked at the marriage documents, birth certificates, English requirement, financial requirement, and accommodation requirement. Now, final area, which hopefully doesn't cause many issues or problems, which is that you need to demonstrate to the Home Office that your relationship is subsisting. So obviously you've got married and a spouse visa has been granted on the basis of that marriage. We are now 2.5 years in. The Home Office wants to be satisfied that your marriage is subsisting. You are still together. How does the Home Office assess that? They take quite a simple approach. They simply want to look at letters and bills coming to the same address for both of you. So the husband gets letters and bills at the same address. The wife receives letters and bills at the same address as well. And they want documents spread out over the last 3 years. So if you were applying now, you would need to submit documents for 2019, 2020, 2021. It's actually not too onerous, because all you're doing is each party, husband and wife, each of them will be submitting 2 or 3 documents per year. So husband will submit 2 or 3 documents for 19, then for 20, then for 21. Wife will do that as well. So essentially, you're submitting maybe 6, maybe 10 documents each, spread out over 3 years. And that's how they assess whether the relationship is genuine. They don't ask for pictures together. They don't ask for letters from neighbours, etc. Nothing like that. Or telephone call history like you do at the outset. Nothing like that. It's simple. Documents come in both your names, either joint names or single names at the same address. So that, in essence, how you extend a spouse visa. We're taking a short break. We'll be back in the next couple of minutes. Inshallah, see you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please feel free to ring on the landline number which appears at the bottom of the screen. If you ring that number, you'll be able to speak to me live and hopefully I'll be able to assist you with any queries that you have. Alternatively, another popular way of getting in touch with me is to send me a message on the mobile number which also appears at the bottom of the screen. That message will be sent through to me here live in the studio and I'll be able to address any questions that you have. We've had a number of questions coming in on WhatsApp, so let's look at the next question that's come in. Okay, now the question is as follows. And I'm reading the question for the first time live on air, so I'm not sure what it is, but it looks like it's an immigration question. In 2011, I did the Life in the UK test. My English is brilliant. Good to hear. I was granted indefinite leave to remain in 2017. I am applying for citizenship. Do I need to do the B1 English test? Or will my Life in the UK test be sufficient? I used the Life in the UK test when I applied for indefinite leave to remain. Okay, so somebody, a viewer, sends in an interesting question. Really, question relates to an application for nationality and which English qualifications are acceptable. Normally, there are two different qualifications which need to be submitted. One is, this is for nationality, one is the Life in the UK test and the other is the B1 test in English. What our viewer is saying is that the B1 test was done back in 2011. Right, as far as that's concerned, that's completely fine, that's acceptable. The Life in the UK test was done in 2011, that's fine, that can still be used now. There is no expiry date on the Life in the UK, for the Life in the UK test certificate. So it doesn't expire after 2 years like many qualifications do. So that 2011 Life in the UK test certificate is acceptable now, 10 years later. So that's not a problem. You asked specifically about the B1 test. Is there a need to do the B1 test? Now, what I'm not clear about is this. When you applied for indefinite leave to remain in 2017, normally you would have done a B1 test at that stage, or you would have met the English language requirement at that stage. Now, if you met the English language requirement at that stage, you've done the B1 at that stage, that would still be acceptable. I know most qualifications expire after 2 years, but if you've used it successfully for an indefinite leave to remain application, if you've used it successfully for an indefinite leave to remain application, and to me it looks like you have, then that qualification is still acceptable at the nationality stage. You don't need to do the B1 test again. So the old Life in the UK test certificate, certainly even after 10 years, is acceptable. The B1 test, I'm assuming that it was successfully used for the indefinite application in 2017. It is still acceptable now, 4 years down the line, because it was successfully used before. Now, just a word of caution here. If you obtain indefinite leave to remain in a category which doesn't require an English qualification, for example, if somebody gets indefinite leave based on the domestic violence concession, so somebody's here on a spouse visa, they're a victim of domestic violence, they get indefinite leave based on the domestic violence rules. There's no English language requirement there. So you might have submitted a B1 certificate, but that was never needed. So if you got indefinite leave to remain in a category where there was no English language requirement, then you can't rely on an old B1 test. You can rely on your life in the UK test. It never has an expiry date. But your B1 test, if you got it a long time ago, more than 2 years ago, and you haven't used it in a route which requires an English qualification, then it may not be acceptable. In the vast majority of cases, let me give you an example. Spouse application, somebody gets indefinite leave to remain, or somebody here on a work permit, skilled worker visa gets indefinite leave to remain. There would be an English language requirement. You might have got indefinite leave to remain 2017. You met the financial English language requirement at that stage. You don't need to do anything new at this stage, even where if you're 4 years or 5 years down the line. Hope that answers that question. If I've missed anything or if you're not sure, please do give me a ring. But to me, it looks like potentially you don't need to do anything further at all. Okay, let's look at the next question. We've got a number of questions coming in. Let's look at the next question. A question relating to elderly parents, whether they can be sponsored to come to the United Kingdom on a permanent basis. It's a question that we actually get quite frequently where elderly parents want to settle in the United Kingdom. The question specifically here is this: can you call your elderly parents to the United Kingdom permanently if they have no children in Pakistan? So the scenario is this, starting point is this, that it's parents who are being sponsored to come to the United Kingdom. Obviously, the children, we don't know who it is who's here. The children are here in the UK. There's nobody left back in, I think it was Pakistan. So parents are there on their own. The question is, can parents be sponsored to come to the United Kingdom on a permanent basis? The problem is that it is going to be extremely difficult to make a successful application, extremely difficult. And the number of applications that succeed in this category are literally can be counted on your hands. I mean, that's how difficult it is to successfully apply for elderly parents to come to the United Kingdom to settle on a permanent basis. The difficulty is this, that up until 2012, there was a rule which specifically said that parents could be sponsored to come to the United Kingdom. There were only two requirements. Parents had to be over the age of 65 and they need to have been financially dependent on their children in the UK. Most cases, very easy to satisfy. Over 65, dependent on the children in the UK. Very easy to satisfy the requirements, and it was easy to sponsor parents to come to the United Kingdom. The problem on a permanent basis, the problem is this: in 2012, that rule was abolished. And if you remember, it's around the time that a significant number of changes that were made to the immigration rules. When we talk about spouses having to earn £18,600 per annum, them having to pass the life in the UK test, that could all be traced back to around that time, 2012, literally about 10 years ago. Now, one of the main things that was done, one of the major overhauls of the immigration rules relating to this particular area was that the fairly easy category, which was used to sponsor parents to come to the UK on a permanent basis, was abolished completely. And in its place, another category was introduced. And that category is extremely difficult. The requirements of that category are extremely difficult to fulfill. Now, if you go on the internet, if you go on the government website, you will see that there is a category there, and it's called the Adult Dependent Relative category. And when you go through it, you look at it and think, you know what, it might be possible to get a visa under this category. Basically, the way it works is if you have parents who are abroad and they are ill, normally they have to be housebound and they need help with personal care. So they might need help with eating, they might need help with having a bath, etc., moving around the house, etc. So if you've got parents who are elderly, and they need personal care, then potentially they qualify under the adult dependent relative scheme. The problem is this, that a visa will only be granted if personal care cannot be provided in the parent's home country. And when they look at whether personal care can be provided in the parent's home country, it's not just a question of looking at whether there are immediate family members there. So it's not a question of looking at whether you've got children there, nephews, nieces there, neighbours there who can assist. What the Home Office does, it actually looks at whether professional care is available in the home country or not. In the vast majority of places now, professional nursing care, professional care is available in the same way that it is available here. Obviously, it has to be paid for. Certainly in the cities, these facilities are available. So there are care homes, there are facilities for nursing care to be provided. And the Home Office's position is this, that it's not sufficient that your parents are elderly. It's not sufficient that your parents need personal care. The question is whether personal care is available in that country or not, even if it was paid for. And all that the Home Office needs to do in order to qualify is to simply demonstrate that, look, where your parents live, take an example, Islamabad or near Islamabad, all they need to do is demonstrate that near where they live, there are care facilities available, care homes or professional nursing care available from a GP practice or from some kind of medical surgery, etc. If they're able to do that, then they can demonstrate that personal care can be provided in one's home country. Therefore, there is no need to grant them a visa to come to live in the United Kingdom on a permanent basis so that they can be cared for by their children, because they can be cared for in their own country. They might not be cared for by their children, but they can still be cared for professionally. And that is the biggest problem that we have with the adult dependent relative category. And that's why the vast majority of applications under this category will end up in a refusal. A couple of minor points just on this. It is quite an expensive category to apply under. The fee is just under, I think, £3,000, and the likelihood of success is not very high. The problem is that point, that the Home Office needs to be satisfied that care services are not available in that home country. That's where the issue is, and it's therefore difficult to successfully apply under this particular category. So hopefully that answers that question. We've got loads of other questions still that need answering. We're going to be taking a short break, and what I will do is, after I come back from that break, we'll address those other questions which have come in on WhatsApp. We'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please feel free to ring on the landline number which appears at the bottom of the screen. Alternatively, the other popular way of getting in touch is to send me a message on WhatsApp on the mobile number which appears at the bottom of the screen. We've had a number of messages that have come in which I haven't been able to address yet. So let's turn to our next question that we've received on WhatsApp. Okay, the question is as follows. Let me read the question out and then let me advise on that. Question from our viewer is this. Hello, sir. I would like to invite my mum here for a 3-month or 6-month visa. What is the maximum she can stay, or what is the maximum I can apply for under the visitor visa category, and what are the requirements which need to be satisfied? I think mother is coming from West Africa, Guinea. Okay, question about a visitor application. How long can somebody apply for under the visitor visa category? That's quite simple. Second aspect of the question is, how do you make a successful visitor application? In terms of the first question here, which is how long can you apply for? I mean, the reality is all visitor visas are granted for 6 months. So even if you ask for if you say in the application that mum or dad, mum here, mum is simply coming to the United Kingdom for 2 months, the Home Office will still grant the standard 6-month visa. Now, in my experience, what I would do is, if it's a first application, mum hasn't been here before, when they ask in the application form, how long will you be staying in the UK? Sometimes my view is asking for, saying 6 months is a bit too long. You might be better off saying, look, you know what, she's going to come and stay for 3 months or possibly 4 months, and then get the visa on that basis. Let mum go back after 3 or 4 months, and then 6 months down the line, year down the line, apply again for another visitor visa. Try and build up a sort of proof of compliance. Mum has come once, stayed for the period that she said she would stay. She would have got a 6-month visa, but in the form where she said, I'm going to stay for 3 months, she only stays for 3 months. So build up your evidence that, look, I comply with the rules. I stick to what I've said. I said I'd be here for 3 months. Obviously, I've got a 6-month visa. I've only stayed for 3 months and I've gone back. Apply again 6 months here down the line. Do the same. Build up your record. Show that you're complying with the immigration rules. So, direct answer to your question is this: that the length of the visa will be 6 months. I think it's always better not to ask for 6 months. If 6 months looks too much like somebody can give up everything and come to the United Kingdom on a permanent basis. And what we're really trying to demonstrate on a visit visa is that this person, mum in this case, has commitments to go back to. Dad might be there, there might be children there, mum might be working, etc. So we don't want to show that there's nothing to go back to. Shorter duration helps demonstrate that there is something that mum needs to go back to. So although you can apply for 6 months, my view is shorten it as much as possible. That's the first issue. Now, the second issue that you ask is, what do you need to submit? Now, it isn't actually that easy to get a visitor visa. There are, in terms of documentary evidence, there are 2 aspects or 2 different things that you need to do. One is evidence from relating to your mum from her home country, and then evidence relating to you as the sponsor. Evidence relating to you as the sponsor, that's straightforward. What you're demonstrating is that you have enough income, savings, you have enough accommodation for your mum to stay with you. So very easy to demonstrate. You would submit your passport copies to show your identity, your wage slips, if you're married, your wife's wage slips or husband's wage slips, and you would submit your bank statements and proof of your accommodation. If you've got savings of about £1,500, that is normally sufficient. So on your part, it's fairly easy. You're demonstrated you can accommodate and maintain your mother. You have enough money coming in, savings, and you've got property. Or if you're renting, that's fine as well. So you need evidence relating to that. And that's okay. The problem is demonstrating that mum will go back. They want to know what will make your mum go back. Does she have other family there? Is there a dad there? Are there children there? Does she have a property there that she owns? Does she have any income in her home country? Does she have savings in her own country? Does she have any assets in her home country? That's where the difficulty is. I know in a visitor application, what you're saying is that you as the sponsor will provide for her needs here, or you will provide for her expenses here. But that's all well and good. The focus is actually on your mother's circumstances, including her financial circumstances, not to see whether she has enough income to live on when she's in the United Kingdom. That's not why she is demonstrating her financial circumstances. She is submitting evidence in relation to her financial circumstances to demonstrate that she lives in comfortable circumstances and she will go back. So the key thing is, how do you demonstrate that she will go back to West Africa? That's the key thing. So I'm going to run through it very quickly. Details of family. Prove that your family is there. Prove that she has accommodation there if she owns it. Prove that she has income there if she has income. There may be rental income, there may be employment income, there may be pension income. Prove that that does exist. Demonstrate what kind of savings your mum has. You know, don't put loads of money into the bank account, because they will want an explanation as to where you've come from. What you're trying to demonstrate is your mother, your family circumstances in your home country are quite solid, so that when your mum comes here and stays for 2-3 months, she will go back. So that's the key issue in terms of visitor applications. It's demonstrating by way of by way of documents that there is a lot there for your mother to go back to. Unfortunately, they have made visitor applications very, very difficult. The other thing very quickly is that you need to make sure that the country that she's traveling from is not on the red list, because if it is on the red list, applications will not be processed. Pakistan is on the red list. Visitor applications are not being processed from Pakistan. We've only got a few minutes left, so I do want to make sure that I do finish all the questions off which have come in. Let's look at the next question that's come in. And our viewer says, my foreign passport will expire 2 months after I become eligible for indefinite leave to remain. For personal reasons, I cannot renew my passport. Will I be able to obtain indefinite leave to remain and remain in the UK for 12 months without a passport until I am eligible for British citizenship? So what our viewer is saying is that viewer has obviously a foreign passport. Our viewer is going to apply for indefinite leave to remain. After applying for indefinite leave to remain, about 2 months after that, the passport is going to expire. Might not be able to get a new passport. Is it still okay to continue with the expired passport for another 12 months and then apply for British citizenship with the expired passport? The answer to that is yes, it's okay. There's no requirement. There's actually no requirement at the indefinite stage or when you're applying for citizenship for you to have a valid passport. I know you're saying when you apply for indefinite leave to remain, at that stage your passport's going to be valid for about 2 months. I understand that. But actually there's no requirement even at that stage for the passport to be valid. There is a requirement for you to have an original passport which may be valid or expired. So in terms of the indefinite leave to remain, not a problem. You'll get your indefinite leave to remain. Understand your passport's going to expire, not a problem. You can wait 12 months and then use that expired passport to apply for British citizenship. Couple of points on that. Firstly, obviously the Home Office might want to know that you have actually lived in the UK, because they might be suspicious. They might think, you know what, you might have got another passport and left the country and you're not disclosing that. So what I would do is try and keep all evidence of your residence for that last year. So whether it's ideal evidence would be wage slips, bank statements showing you're working, money coming in. You've got to be here normally to be earning money. So try and, because you're not going to have a passport which covers the last 12 months, try and keep as much evidence as possible which demonstrates that you are in the UK. And you know, when you apply for nationality, although this is not a requirement, I would just do a letter explaining that, look, my passport expired, I haven't been able to renew it, I do want to apply for nationality, and here's proof that I have been living in the United Kingdom for the last year. That's what I would do. Just a separate point may not be relevant. You just need to look at, you know, when you get your indefinite leave to remain in the United Kingdom, and when you're looking at applying for citizenship, I know you've said, I'm going to have to wait 12 months, which is the case in certain circumstances. In other circumstances, once you get indefinite leave to remain, you are eligible to apply for British citizenship straight away. And the key point in terms of whether you can apply straight away or you need to apply or whether you need to wait for 12 months, the key point is whether you are married if you are married, whether you are married to a British citizen or not. When you get your indefinite leave to remain, which you will do, if you are married to a British citizen, you don't need to wait 12 months. You can apply for nationality straight away. Now, if you are not married at all, or if you're not married to a British citizen, then you are quite right. You do need to wait 12 months before you can qualify for British citizenship. So that's the key thing. When you get indefinite leave to remain, a British spouse means you can apply straight away for nationality. If it's not a British spouse, you can't apply and you wait 12 months. Now, I'm not sure, based on your question, which category you fall into. It looks like you're talking about waiting 12 months, so maybe that is the case. But I thought I'd flag that up, so that's something that you can look at. So hopefully that answers that question. If you're not sure, by all means, do get in touch again. That brings us to the end of the show. Inshallah, we'll be back next week at the same time. See you then.